an eyewitness who was apparently at the scene when Senzo Meyiwa was killed is expected to name Kelly Khumalo as the person who accidentally shot and killed the former Bafana Bafana captain. Defense lawyer Advocate Malesela Teffo revealed this to the court during yesterday's proceedings. The unidentified witness is expected to give a testimony during the trial that's currently ongoing. For more analysis now on this 8-year-long case, let's bring in Director at Dubazana Attorneys, that's Nthabiseng Dubazana, who's with us via our video link this morning. Great to see you as always, Nthabiseng. Thank you so much for making time. So much being said about the reasons that underpinned Malesela Teffo's remarks. What do you reckon the strategy is here?
Well, he put forth this startling, so to speak, allegation during cross-examination. So what happens in a criminal trial is that once you have, done the cross-examination that you feel is necessary based on the evidence that was led by the witness who's currently in the box, you now have the duty to put to the witness in the box the statements or your client's version of events. So basically that's how it's going to come out. So that's why he's saying that there will be a witness that's going to come and testify and say 1, 2, 3, 4, because this is the version that he has been given by his witness, also probably by his accused persons. And you have the obligation to have that version tested before the person comes into the box to testify. Hence, he's putting it to the witness in the box and say, what is your comment on this? What are you saying to this? To give him an opportunity to refute, deny, or add whatever that is necessary to the statement that he has already made. So as a result, the manner in which it was done is not necessarily wrong in any manner or form. It is actual procedure. So what we will have to wait and see is whether or not come the time when the witness is actually called to come and testify, what this person will be saying, and then we have to now wait for the cross-examination from the state to see if that version can be tested and still stand the test of time, so to speak, for the time of for the trial, and then see if it will create enough doubt for there to be for the doubt to be created over the version of the state that these 5 accused persons were exactly the people that committed this crime.
So procedurally speaking, as you say, there's nothing untoward here, but the comments, startling as they were, now there are fears that they're going to put this witness that we don't know under a lot of pressure when they finally take to the stand. Could mentioning this preemptively potentially jeopardize the testimony of this unknown witness?
No, not necessarily. The fact that there is no name, I'm not sure if the name was mentioned, to be quite honest, but in any event, there is no, there shouldn't be any thing that's going to prevent this person to come and testify and give whatever evidence that is there. Like I said, we have to put this version to the witnesses as defense attorneys in order for it to be tested. So when we actually do bring the person to come and testify, during cross-examination from the state, once our client or our witness has testified, the state is going to use what we had put to the witnesses in cross-examination and say, but your attorney said 1, 2, 3, 4, but you are coming and saying something completely different. So we have a duty to put that to the court before we actually bring the witness to come and testify. It's a manner of introducing the viva voce evidence that's going to come to be borne before court. Because unlike the state, whereby they have a duty to give us the copies of the docket, which includes the affidavits and all the statements of all the witnesses, we as the defense parties, attorneys rather, don't have a duty to give the state our witnesses and their statements. So this is a way of having disclosure during court proceedings on what it is that we have in order for it to be used during the trial.
Fair enough. I also don't think the witness was named, by the way, and perhaps that's a good thing. Let's speak about the reaction nonetheless. I mean, Kelly Khumalo's lawyer has been on Newzroom Afrika on this platform and has not minced her words about the exception that they take to these comments being made in court. In fact, she went as far as to say that it tinkers on character assassination. What recourse, if any, does she and Kelly Khumalo have?
At this stage, I don't think they have any, as a result of the fact that this is procedure, like I said, that is being followed. You cannot now come and say that Advocate Teffo is defaming your client when he is putting forth a version that he has been told by a witness or a client. It is court procedure. It is necessary to be done. So you cannot now come and now open a civil suit against him, whereas it's within the correct process and procedure of court. So at this stage, it's just a matter of doing what they're obviously doing, which is saying these comments are not true. They take exception to 1, 2, 3, 4. But be that as it may, they just have to wait it out. If at the end of this trial and the accused are found guilty or not guilty, doesn't matter. But the character assassination now continues outside of the trial, then they have a leg to stand on to open a civil case, because it's not within the bounds and protection of the trial court.
I hear you. I can imagine, though, some people saying, but hold on, there's a whole environment, climate to be considered here. We know that the conspiracies around this trial have been unending. That Netflix documentary, I don't think, is helping. And it's in that context that, I guess some people feel there should be a level of... it's kind of incumbent on the advocate to be circumspect in what he says. Your take is, in fact, given the fact that procedurally he can't be faulted, what he says can't really be criticized.
100%. I mean, if there was any time to take any exception to what he's saying pertaining Kelly Khumalo and the people who were present in the house, would probably have been about 4.5 months ago or 5, when he made that SABC interview, which is about 30 or so minutes long, where he spoke in so much detail about the 2 different cases that were opened for this Senzo Meyiwa murder trial. He goes into which one was then put in the back footer, and who the people were removed from there, who the people who are suspected to have covered up were, and all of that. That would have been the correct place to now say, no, you're defaming me, because the matter had not been put on the roll for trial at that stage. It was still in investigation stage. But now where we are, you cannot now bring that application as yet. You would have to wait for the trial court to be done with the trial. And then if it continues thereafter, then you can proceed with applying for your defamation of character.
Kelly Khumalo's lawyer has also told us that they find it strange, and I'm paraphrasing, that the men who've been accused and are now standing trial haven't been brought forward to be identified by the individuals who are said to have been in the room when Senzo Meyiwa was killed. Do you find that strange?
Indeed, because if, from what we saw, at least on the documentary that has been released, it seemed that they didn't have their faces covered, so they would be easily identifiable, I suppose. I think I may be wrong about how they were seen. But if indeed the people in the house were able to see their faces, there should have been an ID parade for them to confirm. But be that as it may, perhaps they could have been linked by virtue of forensic evidence, because what happens is that if you get arrested today for whatever, they do take a DNA swab and it's put within the system. And then if they collect a sample 10 years later in some crime some way, then they put it in the system. They don't need to have you identified, because you're already identified by your DNA within the SAPS system. So that could possibly be the reason why there wasn't an ID parade that was conducted. But if that's not the reason that they were brought forth, then indeed it would be strange that an ID parade was not conducted. But then considering that the time was at night, there might be issues with identification as well. So it is I think the state did a balancing act and decided that let's see how it goes based on whatever evidence that they had acquired to bring these accused persons forth to the court.
Never a doubt there around this case. Thanks very much indeed for helping us connect the dots as best as you can. Nthabiseng Dubazana, appreciate your time on the AM report this morning. Nthabiseng is the director at Dubazana Attorneys.